Awesome. Hello, everyone. I'm excited to have you all here. Today is Thursday, and we are hosting one of our first of this series, the Community Conversation series on housing in Austin. So today, I'm just going to go over a little bit of the technical assistance piece and make sure everyone feels comfortable with using their chat box. If you can go ahead and in the chat, go ahead and put your name, your position title, and your pronouns as well in the chat box, just so we can get to know one another as we go through this training as well, and that you can get comfortable with using the chat box throughout the training. We will be having this training session for the next hour or so. We'll have a quick 15-minute Q&A portion at the end. So if you have any questions, write them down, jot them down, and then at the end, if we have enough time, we'll try to get to as many questions as we possibly can. But I'm really excited to be here with y'all. And we have a topic area that is really cool and interesting. And we have Austin Tenants Council that's going to be really presenting on fair housing and the basics of what we need to do and know in Austin when it comes to serving different populations of people and renters in Austin. So I'll introduce Alec first. So Alec Rees is the Fair Housing Program Director at Austin Tenants Council. Alec relocated in 2021 from his hometown of Charlotte, North Carolina, where he spent time working with legal nonprofits, government agencies, and educational organizations. He has a BA in English Literature from Elon University and received his JD from the University of North Carolina. He is passionate about housing justice and empowering communities to stand on their right to equal access in Texas and beyond. One of our co-presenters today is Giovanni Zamora, is the Fair Housing Assistant Program Director for the Fair Housing Program of Austin Tenants Council, which includes fair housing enforcement, training, and supervising staff. And she oversees the Fair Housing Testing Program that entails the recruitment and training of volunteers who want to become fair housing testers. In November 2021, Ms. Zamora became the Fair Housing Assistant Program Director. Ms. Zamora graduated with a minor in social work from Austin Community College in 2012, and then graduated from Concordia University, Texas, with a degree in psychology and sociology in 2014. Ms. Zamora believes the training she received, along with her life experiences in education, provides a solid foundation for fighting housing discrimination in Austin and the metro area. I'm so excited to hear what this training has today. And just please feel free to use the chat box if you have any questions. And I love to see all the introductions of who's joining us today. So I'll pass it over to Alec.
Hi, good afternoon, everyone. Thank you again for joining us. As Lyric said, I'm Alec Rees, Fair Housing Program Director. I just wanted to give a brief heads up, as I do in all of my Zoom meetings. I have a very large, very sweet Anatolian Shepherd puppy. He's having a nap right now, but there's always the possibility he'll feel like he needs to tell us all about local squirrels or something. So if that happens, I'll just go ahead and mute myself, throw it to Giovanni, and come back when he's settled. But just to let you guys know, so we don't have a surprise. But I guess we can go ahead and get started. Giovanni, like I said, feel free to jump in whenever you are ready. So the Austin Tenants Council primarily works on federal discrimination issues. There are some local Austin fair housing provisions that are a bit more expansive. And if we get a call from a tenant who is interested in pursuing something on one of those bases, we can always direct them to the Austin Office of Civil Rights. The Fair Housing Act of 1968 is primarily our purview. The Fair Housing Act of 1968 protects renters and home buyers from discrimination based on their membership in one of the 7 federally protected classes, which are race, color, sex, religion, disability, national origin, and familial status. Familial status just refers to families with children. So what is discrimination? I think a lot of times people, we get calls from folks who just feel that they've been mistreated and, want to want to pursue something, but when we have to really hone down as to how they're being treated differently than other tenants based on their membership in one of the 7 protected classes, which is different from just being treated poorly and also being a member of a protected class and like a separate box over there. Some pretty common. Sorry, I think I got muted there for a second. Can y'all hear me? Oh, okay, great. Some common examples of discrimination that we see: refusal to rent, falsely denying that housing is available, offering different terms and conditions for renting, applying different tenanting criteria, higher credit scores, or requiring co-signers when they wouldn't normally, that kind of thing. Harassment, quid pro quo, hostile environment, our classic sexual harassment examples. Expression of preference in advertising. This can be, this can be very explicit, or it can also be pretty subtle. One of the ones we were just talking about before y'all joined the call is no pets allowed, which implies that disabled folks who are using service animals may not be welcome. Failure or delay in the performance of maintenance and repairs. Austin Tenants Council does have a housing advocacy department that handles most of the repairs calls that we get, and mediates on behalf of tenants who have repairs issues that aren't being addressed that threaten their health and safety. But occasionally you do get failure, delay in maintenance and repairs that are based on membership in a protected class. Then it would fall to us to handle, assuming they wanted to pursue a fair housing complaint as well. Limitation of privileges, i.e. your children are not allowed to use the pool area. Eviction of tenants' guests that are depending on what the provisions are in the lease in terms of guests. Okay, so to just drill down on a couple of the definitions of classes, sex discrimination is a little bit controversial at the moment in terms of what we mean by sex. Everyone agrees that it includes sex assigned at birth. Currently, it does also include gender expression, gender identity, and sexual orientation. The Biden administration is choosing to extend this 2020 Bostock versus Clayton County decision. This was a decision that dealt with Title VII sex discrimination case in the workplace, and the language of the 7 protected classes in that piece of legislation is almost identical. So it seems natural that it would extend across a bunch of different similar provisions, but the previous administration, the Trump administration, chose to interpret it differently and only defined sex as including sex assigned at birth outside of the Title VII context. And assuming Congress doesn't act, and there isn't a Fair Housing Act challenge in the Supreme Court similar to Bostock, it's always possible that the definition could change based on the administration and what the administration's agencies choose to do. Should that be the case, at least in the city of Austin, gender identity, expression, and sexual orientation are explicitly covered in the city's fair housing ordinance. And if we are unable to help, we can always direct tenants to the OCR. Okay, so just a brief sort of trigger warning. I'm going to talk a little bit about the Fair Housing Act and survivors of domestic violence, stalking, sexual violence. A lot of that would again fall to our housing advocates, because there are specific provisions in place for helping victims of domestic violence and abuse get out of their leases without penalty in certain cases. But domestic abuse is also considered a gender-based crime and can also intersect with other protected classes. So there are some fair housing protections that apply. Essentially, they have to do with landlords being nervous about renting to victims of domestic violence because they feel like that will attract some kind of drama. Some landlords, claim that they have a zero tolerance for crime policy, which somehow leads to them, excluding victims from crimes from the property, or refusing to rent because they don't want to attract trouble. All of these things are unlawful under the Fair Housing Act. Disability, another one that can be a little slippery. It's defined as an impairment that substantially limits one or more major life functions. And that is a very, very broad definition. It's also just as an aside, it's the same definition that they use in the Americans with Disabilities Act. I think a lot of times when people are talking about accommodations for disabled people, their instinct is to talk about the ADA, but that's a separate thing. That covers public accommodations, versus the Fair Housing Act is what applies in situations with the renters. But this broad definition is broad by design. When they passed the first version of the American Disabilities Act, where they developed this language, they made it much more specific. But then what happened was pretty much every case they were seeing, every complaint they were seeing was coming down to, does it fit in this definition of disability that Congress wrote up? And it came to be that like nothing was a disability. And no one was being protected from disability-based discrimination. And so when they revised the Americans with Disabilities Act, they changed the definition to what you see here, and this extends to the Fair Housing Act as well. So basically the idea was that we're going to just try and get everything over the threshold so that then we can deal with whether or not discrimination has occurred or an accommodation is appropriate. And that can be the thing that we discuss. Under this definition, a disability can be physical or mental. It can also be temporary. It does not have to be a permanent condition. A sort of a classic example is that while a regular pregnancy does not count as a disability, because that's sort of just a fact of life, a high risk pregnancy might be considered a disability, even though it will end after 9 months. An important side note, HIV/AIDS also considered a covered disability, even when it is asymptomatic, because it can limit reproductive function. There was a case called Bragdon versus Abbott, where they tested this out with a dentist who would only perform routine cleanings on HIV positive folks in a surgical suite, which basically meant he would not perform them. And so it doesn't even necessarily need to be something that is obvious, that is hindering, your sort of classic walking, breathing. It can be things that are invisible. So reasonable accommodations and modifications. One of sort of the most common things we get with our disabled clients is requests for reasonable accommodations and reasonable modifications to their units. The Fair Housing Act requires these modifications in order to ensure that the disabled have equal access to the full enjoyment of their unit. There is no stated definition of what's reasonable, which is sort of where the difficulty comes in if the landlord isn't initially inclined to be accommodating. Generally, when it comes to when it is in question, the test is sort of how necessary is this accommodation? What kind of burden does it impose on the landlord to make it, usually financially speaking? And is there a less burdensome alternative that would meet the need? So these are sort of some classic examples of reasonable accommodations: assigning a handicap parking space, release from a lease without penalty if there's some kind of issue. If there's some kind of issue that can't necessarily be resolved. We had a tenant who had PTSD and being on a first floor unit, hearing the noise coming from above her. It was regular sort of apartment noise. It wasn't anything excessive. There wasn't anything they could do about it. So options for her were to be transferred to a sister property, transferred to a top floor unit, or to be released from her lease without penalty, if one of those units wasn't available. You can also ask that a live-in caregiver be permitted to occupy a unit without being added to a lease. Typically, if you have someone who is living with you, they need to be on the lease unless they are a child. But a live-in caregiver would be someone who would not otherwise be occupying the unit were it not for the need to give care. So if your spouse who lives with you is also, is also acting as a caregiver, that's a different situation. But if it's like an outside person who would not be there, but for, that is an accommodation that pretty easy to make. Reasonable modifications. So the difference with the reasonable modification is that it is a change to the physical structure of the unit. A tenant requesting a modification has to cover the cost of making the change unless it's something that should have already been in place. Properties built after March 13th, 1991 are subject to certain accessibility requirements. And if those haven't been done, and that's what's being requested, then the property does have to cover the cost of making that happen. Otherwise, the tenant, if they're requesting that this change be made, they have to cover that cost. And when they move out, they may have to cover the cost of reversing any modifications they've made, assuming that that it is something that would not be desirable or neutral to a general audience in future attempts to lease the apartment. So some common examples of reasonable modifications: widening doors, lowering the entry threshold, lowering countertops, sinks, cabinetry, light switches, installing ramps, installation of bathroom grab bars, and switching out door handles for lever door handles for folks who can't necessarily grip the door handle. So if you're asking for a reasonable modification or a reasonable accommodation, a property is allowed to ask for some kind of documentation indicating why you need this accommodation to be made. So you need to get a clinical professional to write up saying, creating a clear connection between your disability and the need for what you requested. Then it doesn't necessarily, I say clinical professional incidentally because it doesn't always have to be a medical doctor. Sometimes we get folks who, we get property managers who demand that it be from a medical doctor when we're dealing with something that, like a therapist or, a psychologist could write up a recommendation for. So when we're talking about the Fair Housing Act, there are a couple of types of landlords who are exempt from the Fair Housing Act, so none of this would apply to them. Is there the single family home exemption and the Mrs. Murphy exception? So this would be, someone who doesn't own more than 3 single family homes at a time, and also someone who lives on the property they're renting, and if that property has 4 units or less. This second one sort of sticks in my brain because they call it the Mrs. Murphy exemption, because when they were writing up the Fair Housing, a congressperson stood up in front of Congress and spun a tale about a fictional Irish widow named Mrs. Murphy, who in the absence of her husband had to turn her home into a boarding house, and God forbid she should have to rent to someone she finds undesirable. So that person would not be required to adhere to the Fair Housing Act. So I'm going to get into now a little bit about our program and the kind of services that we provide. So in addition to doing trainings like this, general fair housing education, we also draft and submit reasonable accommodation requests for tenants. In order to work, these sorts of letters have to use very specific kind of language. And also sometimes property management is more inclined to be accommodating if the language sounds formal, if it's clear that there's like a third party, acting as their advocate. There's this sort of vague implication that lawyers could be involved. We're not lawyers at ATC, but just the sort of the hint of any kind of legal enforceability law being cited does tend to make people a little bit more accommodating. We also are able to communicate with properties on behalf of tenants regarding fair housing matters in general. Sometimes it doesn't necessarily need to escalate to a complaint or, a formal written request. Sometimes you just have to give them a call, make it clear that, someone is acting on behalf of the tenant. They're aware of their rights and they plan to stand on them. Sometimes that's enough. And also, when tenants do file formal housing discrimination complaints, we're able to help them, through that rather bureaucratic process, and then serve as their advocates throughout that process. So 903, we call those formal complaints 903 complaints. So discrimination occurs based on any of the protected classes, and this, as I say, there can include the denial of a legitimate reasonable accommodation request. Tenant has the right to file a complaint with the Department of Housing and Urban Development. Our fair housing specialists help file this complaint with you, and they will serve as your advocate through the entire process, from filing, processing, investigation, conciliation, and decision, and possibly appeal. The processing part used to be just sort of like them entering in your stuff into the system, checking if there's the gaps in what you've provided that they might need. Now it's almost like a pre-screener, wherein the folks doing the processing are kind of making their own judgments about whether or not they want to put it through to the investigator. So that can require some back and forth. The investigation process, if it gets through processing, they'll assign an investigator that's someone who either works for HUD or works for works for an organization that has been authorized by HUD to conduct these organizations on their behalf. So they'll talk to the parties involved. They'll ask to see any documentation you have. If either side wants to provide a witness of some kind, that might be a factor. And then conciliation, I would liken this, again, this is not a court process. We are not lawyers, but this is an administrative process that goes through HUD. But I would sort of liken the conciliation process to a settlement offer in a court case. Basically, at this stage, I'm so sorry. At this stage, the investigator and the property might offer some kind of settlement, some kind of monetary consideration, some kind of they might offer to do, to take fair housing training, give free rent. I've seen some stuff about like putting up signage on the property, issuing an apology, those kinds of things, all possible. And the tenant is free to accept this and let the complaint drop, or to not. This is, we may advise the tenant on, if this is, the best offer they're likely to get. Sometimes if tenants sort of drag their heels or reject a conciliation offer that is good, sometimes that will lead to the investigator moving forward to the decision phase and their complaint being dismissed for no cause. So we're always trying to make tenants aware of that possibility, but it is ultimately their decision if they want to accept this or if they want to move forward to the decision process when the investigator make a formal determination about the complaint. If the complaint doesn't go their way, we may also be able to assist with an appeal. Appeals are only allowed and only appropriate when new information that wasn't in the original complaint has come to light. If it's just that you feel like they didn't assess the information you provided correctly, they're not going to take that appeal. Okay, testing. So we also have our fair housing testing program. Giovanni, if this is Giovanni's baby. She ran this program for a number of years, and so I'm gonna cede it over to her to talk about it.
Hello guys, thank you for having us. The testing program that we have is part of the fair housing program, and all of our fair housing agencies have such a program. It's a very strong way of supporting our clients' claims of discrimination, whether it's on any of the protected classes. And what they do is we have testers, volunteers that we recruit throughout the community. There are restrictions that the candidates are given before they become a tester, according to HORD guidelines. And it's a very structured process. It's very, very important that we adhere to all the HUD guidelines when we are obtaining our testers, because we want to make sure that the evidence that the testers are collecting are unbiased, because we're not out there trying to set anybody up.
Giovanni,
Yes,
can I interrupt you just a bit? Some of the participants are having a hard time hearing you.
Okay, I'm terribly sorry. I'll try to speak up a little bit louder.
That's already better, so thank you.
Okay, thank you so much. I'll just lean in a little bit closer. I'm sorry about that. So as I was saying, when I'm explaining fair housing testing, it's a structured process that we use to support all of the complaints that we receive. Our agency recruits testers, and they're volunteers. They are fully trained by myself in order to what the information that they're trying to receive. The testers are given a script, and they're told to be unbiased and strictly go by what's on the information. There's no guesswork in anything that they're doing. The Supreme Court has acknowledged our testing as a valid way to measure whether or not housing providers are actually adhering to the fair housing laws that are covered under the Fair Housing Act. It's so important because we use testing, because unfortunately we have discrimination that is still ongoing, that we are unable to see just like with the naked eye. Even though we think that slavery and everything is over with, there's still so much discrimination in housing against parents, disabled persons. And testing is a great way to find out if that housing provider is actually discriminating or not. We are always recruiting for testers. So if you are interested, please let us know at the end, and we'll contact you after the presentation. But because the housing discrimination is so not seen, it's very, very important that we use these testers. What we do is we send out, let's say, on every test, we're sending 2 people out. Well, not out because due to the pandemic, but we're having 2 people contact a housing provider, and where they're given a script of what to ask for as far as, okay, what's available, how much is it, and what's the rental criteria. Really basic information that every renter usually asks of an apartment complex or a housing provider of any kind. And our hopes, of course, is that the information that they return is all the same, that there's no difference in the treatment, that everything is the same. Oftentimes, it's not that way. And that's when we take it a step further and we report it to HUD and move forward with a complaint. Again, it's a really structured process. It's a lot more than what I could tell you on this event, because even I was trained, I had to spend like at least 2 weeks in training just to be a test coordinator before I became the EV director. So it's a really, really intense training that all of us go through in order to train and recruit and gain reliable and honest testers.
Okay. Another program that we're sort of in the process of soft launching at ATC is our Impact Austin Community Advocate Program. It's called the Impact Austin Program because it's being funded very generously by a women's collective giving organization in the area called Impact Austin. Basically, the program is that we are taking volunteer consultants who we'll call the community advocates. We're giving them very basic training just on similar to what we've done here, but just mostly on ATC and what our services are and when they might be appropriate. This is not a position where folks are going to be giving out fair housing advice. You know, we as Giovanni said, there's a lot of training and there's a lot to know, and we recognize that like we can't be asking folks to, you know, basically take on a second job with us. But so it's just training on what we do here, and after they receive that training, they're gonna find opportunities, and maybe we'll direct them to some opportunities to reach out to their community members peer to peer and talk about it. And this could be, you know, we often go to like a lot of formal like tabling events and trainings like this, but ideally this would be places where you can reach people where they are. And then once they've had these meetings, they'll have regular sort of interactions with, they'll have regular meetings with us. They'll talk to us about, you know, what they've been hearing, what they've been seeing, and hopefully give us some insight that maybe we wouldn't otherwise get on what the community needs most from us. And, you know, what, if any, sort of services or gaps that, you know, that we have in our, you know, in what we're providing that we could be doing better on. Okay, and this is just our contact information. That's our office phone. So if you call that, you'll get our great receptionist Miriam, and she can direct you to either the counseling line or to one of the fair housing folks. And the counseling phone would take you directly to the housing advocates, where they tend to spend you know, maybe 20 minutes with folks, like talking them through issues, assuming that they don't move on to a mediation phase. So they have more of a hotline structure than we do, because some of these complaints can take, the complaints that we take can take many months. But if someone calls the counseling phone and it is what they suspect to be a fair housing issue, they will refer it to us, and someone will reach back out. Our web rights.org has a lot of our resources, a lot of fact sheets, some FAQs, and also a list of other resources aside from ATC that can help folks with issues outside of the scope of what we do. Some legal services, free low-cost legal services. Some, when we can find them, some places that offer rental assistance and et cetera, et cetera. And also, you know, Austin OCR, all of that contact information is up there. Also, you can file an online complaint with us. That's the one for fair housing. There is also an online complaint form for housing advocacy. If you're having trouble getting through over the phone, we do get more calls than we can answer in a day. So one of the fastest ways to get someone to reach back out to you is by filing the complaint online. Our office at 205 Chacon is currently closed to the public. There was a time, and maybe a time again, where we take in-person appointments. We did an open house last month, and had, you know, sort of just invited the community to come and hang out with us in our backyard and get some fair housing information. But in general, we're trying to do most of our work over the phone and through the website right now. So that's all I've got, unless Giovanni, you wanted to add anything additionally, but if not, we can kick it to questions.
I'm good. My sound is a little bit muffled, so I don't have anything to add right now.
Okay, great. If you think of anything, feel free to chime in.
Okay, will do.
I did keep track of the questions in the chat, so I'm going to go ahead and post them here for y'all, but we had a few questions from the participants, and I just listed them all right now in the chat.
Okay, great. I'll just have a look really quick. Okay, so what happens after a complaint is filed with HUD. So I talked through that a little bit, but I can go into more detail if any folks have specifics that they want to address. But basically, they do an investigation and they make a determination. And there's there should be, and if things don't fizzle out during the conciliation phase, or if the tenant occasionally we get tenants who decide they aren't interested anymore or who become impossible to get in touch with. Assuming we get all the way to the decision phase, then they make sort of a formal determination, and it goes on the record, and there are penalties. How do we engage with ATC? Well, I think we do take volunteers for the testing program. If you're interested in that, feel free to reach out to us. We also are currently, interested in doing some recruiting for Impact Austin. So if any folks are interested in that, or if they know folks who might be, feel free to send them our way. We also, like I said, we do trainings like this. We go and do tabling events. And we're always happy to, if we have availability, we're always happy to send someone out. Let's see, how does one become a tester? I think that would be a question for Gio, if you want to talk a little bit about that.
Sure. In order to become a tester, all you need to do is just contact me, and we could set up a time for you to train. Attend a one-time training. The training lasts about 2.5 hours. And I'm very, very flexible. We can go according to your schedule. Most of my existing testers, they're either already employed or they're college students. So I'm very, very flexible with when you get trained. But you get trained and it's very informal. And then after your training, then we will make you an active tester. But the first step would be to, contact me, and I can put my email and phone number in the chat. And then we can schedule a training and dig deeper into what the requirements are.
Yeah.
Awesome. And we had 2 additional questions around, are there any protections for people with criminal histories as well as people in housing programs?
Okay. It looks like there's one more on the end of that first message. What are the times for the counseling line? Those are also on our website, but I can share them now as well. I'll actually put them in the chat. The counseling line is open Monday through Friday from 8:30 a.m. through 12 p.m. And then also Monday through Thursday from 1 to 4. Put that in the chat. And also fair housing, like I said, we're not on the chat line, but we do, we're generally in from 8:30 through 5. Whether or not we're available is a different question, but we do continuously take referrals and complaints throughout business hours, Monday through Friday. Okay. So yeah, so protections for individuals with criminal histories. So not as much as we would like. There are like second chance properties that we can, that do, take people with records. And that's always a good place to look if you have someone who's got a criminal history, who's looking for fair housing. Also, but the primary sort of issue with criminal histories has to do with, we tend to deal with is with Section 8. If you are on the Section 8 waiting list, trying to get on the Section 8 waiting list, which has been closed for quite some time. So I assume if you're on the waiting list, they did just recently change their policy to provide greater protection for people with criminal histories. And so what they've done, removed a bunch of misdemeanors from their look back from the criminal histories that they check. And they've also changed the look back period. So they're looking back into your criminal record for less time. So if you have an offense on your record from, 2 years ago, now that might not be an issue versus 1 year ago. Okay. Hopefully that answered that question, but like I said, it's something that a lot of folks are really passionate about and working on, and certainly a huge gap in fair housing protections. Okay. Are there any protections for people in housing programs? I assume by housing programs, they mean like Section 8, so yes, but source of income discrimination is only an Austin, a city of Austin protection, and only for veterans. So if you're getting your housing money through like a Veterans Protection Act, that is protected in the city of Austin, not in the on a broader scale. That's not a federally protected class. Other than that, I'm not, if you have a follow up to that, if there's a specific program you had in mind, I'm happy to go a little further into that.
And then Alec, we had a hand raised from
yeah,
Andrew Ward.
Sure thing.
Hi, Alec. Kind of going off of that last question for housing assistance, I know that the Continuum of Care program and the Emergency Solutions Grant program, which are both HUD-funded housing assistance programs, have in their regulation compliance with the Fair Housing Law. Is that indicative of any housing assistance program or program designed to assist individuals getting access to housing? Do the fair housing protections extend to eligibility and preference within those programs?
So the Fair Housing Act will, I think if I'm understanding your question correctly, and feel free to correct me if I'm not, the Fair Housing Act does apply to folks that are receiving housing groups that are receiving federal money or federal tax preference. So federal tax credit properties are required to, for example, provide for non-renewal of lease, whereas privately owned properties are not.
So I'm not asking about the actual properties. I'm asking about for programs that help individuals. So for example, the Continuum of Care funding funds either permanent supportive housing programs or rapid rehousing programs. Can a rapid rehousing program say, for example, I will not serve someone unless they have a specific disability type, or would that be a violation of fair housing?
Oh, well, that I don't think would be covered under the Fair Housing Act.
Now, they do say in the regulations that those Continuum of Care programs have to follow the Fair Housing Act,
and that
as established under the HUD regulations.
Right, that would be a regulatory issue, but it's not in the act itself. So that's probably another one of those things that could vary by administration and vary by source of funding. So if they're getting, if the program is getting federal funding, chances are that regardless of the program, it's going to be held to those federal anti-discrimination standards.
And that's what generally we see in the COC and ESG regulations, saying you must comply with anti-discrimination as found in the Fair Housing Act.
Right.
But I just want to see what your thoughts are on that.
Yeah, but if they're not getting federal funding, like a good example of this is the Salvation Army. Salvation Army, private and also religious, they discriminate all the time in their provision of services and rehousing and shelters, etc.
Would the same, I know you guys don't focus primarily on City of Austin ordinances, but would a housing assistance program that's funded through the City of Austin have to comply with the City of Austin's anti-discrimination ordinances?
Generally, yes.
Okay.
I would always, to your point, it's always a good idea to check the regulations. You'll read the fine print, but in general, if you're getting funding from the government, there's gonna be those kinds of strings.
Cool. Thank you.
Sure thing. Let's see. Would ATC be the appropriate venue for concerns regarding billing errors by apartments that are not being resolved? I think that would not be a fair housing issue, that unless it's unless there's the billing error somehow and the resolution is somehow discrimination related. But the housing advocates, I think, could do some kind of landlord tenant mediation on something like this, or at a minimum provide advice for a tenant on how to advocate for themselves in this kind of conflict, and help them document it and make sure that they're crossing all their T's and dotting all their I's if should this progress to small claims court. So yes, I think that could be worth giving the counseling line a call on that kind of an issue. Let's see. Are testers paid? Yes. I think it's $20 per phone call. Is that?
Yeah, it's $20 per phone call, and if we're doing our tests vary throughout the year. We have a contract with HUD, and HUD where we commit to do certain forms of testing. So, and some testing will pay a higher stipend than others. For instance, this year, we're going to be doing some sales testing in the home buying process, and that stipend is $50 per each assignment.
Yep. And did you mention, sorry, I was trying to read the next question, that we reimburse for mileage?
Yes.
Okay, perfect. I see a hand is up. Linda Jackson?
Yes, I wanted to expand kind of on Andrew's question. I found that very interesting. Say, for instance, there's a nonprofit that helps provide assistance for people with a specific disability. The one that pops in my head first is for those who are HIV positive. They only give that assistance to those who are HIV positive,
Mhm.
for reason of that being their mission. So does that mean that with the fair housing thing, does that mean that they are not allowed to not provide that service to other entities or to other people?
If I think I'm understanding your question, so again, it would depend on the source of their funding and the nature of the scope of their work is. If you're asking, like, are they allowed to limit their clientele to folks who are HIV positive, then yes, they are allowed to do that. That's
Okay.
That would be like, that's the scope of their mission. It's not like they're saying we're helping the disabled, but not people with HIV. That might be something different. Or we're helping the disabled, but not disabled people of color. Then we would get into something more discriminatory.
Okay.
I see a second hand. Donna, where?
Yes.
Oh no, my screen is frozen. Shoot.
I think we can still hear you.
Oh, okay. I think you're back. You're back. Sorry about that.
Yeah.
Yes, I'm sorry. Can you start your question again?
Oh, okay. I said, does the council address the neglected rights of disabled and elderly? Like when we're subjected to violence and robbery and theft at our residence? Or is that someone completely different? Because does that go under fair housing or?
Are you referring to like hate crimes, if I'm understanding you?
No, just the residents where I live, there have been robberies, there have been elderly that have been pushed over and their purses taken, and other things have happened, and there's drug use and robbery on site.
Mhm.
And we've gone through the management, but we keep losing managers. And so we're only, what do you call it, protected by the district level will come in like once a week. Send someone to just check and take payments and things like that. But we've been going through this now for about 9 months of the 16 months that I've been living here. And it's getting more dangerous. And we don't know who to go to get help.
Okay. Well, I'm so sorry thing y'all are dealing with. That's I'm sure that is very scary to be living with. In terms of that, it does not sound like it's the kind of fair housing issue that's been within the scope of something that I'm able to that we're able to advise on and deal with. If it is a property that receives a tax credit or
Yes.
that takes that has folks on Section 8 vouchers, that
Yes.
might be something to reach out to the city about.
The city. Okay.
Yes. And I can put some resources in the chat before I go for ways to contact the city.
Okay.
Sure thing. Is your Andrew Willer, is your hand still up, or maybe you have another question?
I have another question. Sorry.
No, please.
I'm just wondering if you could speak for a second on how properties are able, or just around kind of age specialization for properties, either senior housing or youth housing specifically, and how that either falls in line with or what we see with regards to fair housing and those kind of properties.
Sure. Age is not a protected class, so they're free to discriminate however they like there. At least it's not a protected class in the Federal Housing Act. In the city of Austin, it is.
Yeah.
Oh, I'm sorry. Is that what you were trying to say?
Yeah.
Yeah, age is not a federally protected class, but it is a protected class in the city of Austin.
Yeah.
So that depends on what you're talking about.
Yeah.
Was there? I'm sorry. Did you have more you wanted to add there, Giovanni? Don't want to step on your.
Yeah. I mean, it's unfortunately we cannot assist that person under the Fair Housing Act. However, we can get that person to a member of the city of Austin, their civil rights, and they can address it under this their city ordinance that has additional protections.
Mm-hmm. However, I think if you're talking about, I assume you're not speaking about like 65 plus communities in general.
Yeah, I'm wondering, how does that work when there is, City of Austin has a local age protection ordinance, right?
Mm-hmm.
But there is properties in Austin that are 65 and older dedicated housing.
Mm-hmm.
I understand, and I would assume that, if there was a household that applied to that housing and it was a 2-bedroom and there was someone under the age of 65 as part of the household, but the head of household was over, that wouldn't be a violation, as long as they admitted them. But, how can it just exist with the city ordinance under age discrimination?
Giovanni, did you have thoughts on that, or do you want me to?
You can, but usually everything that's like age related, if the person thinks that they've been discriminated, I automatically transfer that person to the civil rights department and for the city of Austin, because they handle those age discrimination complaints.
Yes, and that's a good thing to point out, is that in general, our job is not to make a judgment about our job, and I think the city would those folks who process those complaints would agree that it's not our job to make a judgment call on whether or not discrimination has occurred. If the person feels they've been discriminated against, it is their right to complain. But with the 65 plus communities, I actually have not thought about this very much, but if there were there are places like that are not like nursing homes, but that are like single family homes that do have to accept like 20% people under 65 and they're out of their community in order to be compliant with local law, local ordinance. So I think that I would need to look more deeply at the regulations and see if there are carve outs, because I'm not as familiar with the Austin anti-discrimination protections as I am with the federal ones. But there are, to your point, some instances where they're gonna have to strike a balance to be compliant with local law. I actually have I have a friend who lives in a 65 plus community and is 25 for that very reason.
Cool. Thank you.
Sure. Linda Jackson, do you have another question? Is your hand still up from before? Okay, feel free.
I tried to regroup in my head. I had other questions happen as you were talking. Like with the okay, we are dedicated to aged and disabled tenants.
Mm-hmm.
Does the Fair Housing Act, or does it accommodate for things like tenant on tenant issues like bullying, things like that? Does the Fair Housing Act require the management to address those issues appropriately?
Not necessarily. So the issue that I'm thinking, that the issue is like, how are you being treated differently? So if the landlord, like as a policy, intervenes in these kinds of things, but is all of a sudden like not willing to protect you when it is based, when the harassment is discriminatory, then you might be able to say, well, they're excluding me from services that they normally provide, like tenant mediation, because they are discriminating against me based on a membership in a protected class. But as a general matter, if they have a policy, if their thing is, I'm not getting involved in like inter-tenant disputes, regardless of who's involved, then that's a policy they're allowed to have under the Fair Housing Act.
What about here in Austin, apartment, are there certain accommodations that are required across the board, like handicap ramps, wheelchair ramps, things like that onto properties that are multifamily units?
Well, I think I mentioned earlier that if the property was built under the Fair Housing Act, if the property was built after March 17th, 1991, something like that. 14th, yeah. I think she was mouthing 14th. Yes, then. Thank you for that. My brain doesn't retain numbers, which is why it's why everybody goes to law school, because we can't do math. But if it was built after that time, then they are required to meet certain accessibility benchmarks. Have like at least accessible units on the first floor, or needs ramps to the leasing office. I couldn't go through them off the top of my head, but there are certain accessibility requirements that they're required to meet. If it's a building that's older than that, they're not subject to those requirements as a matter of course, and you may have to request them.
Okay, I have a specific question. What about like if when someone moved into a property, that accommodation was there and then it were removed after the resident?
That's really interesting. If it was a property that was required to have it and then they removed it.
Yeah, it's not, it was older. It's an older property. Because it's my apartment complex. When I moved in here, there was a wheelchair ramp and went to the first floor. And when they redid the parking lot, they removed it and it's no longer there. Because when I moved in here, that was a requirement for me to live here. And now it's gone. The same with the building across the parking lot. There was a gentleman that used to live there in a wheelchair. And when I first moved in here, there was wheelchair accessibility, and now there is not.
Well, that's definitely something that I think you could request that be put back. But as the question of expense there, I would recommend, if you're interested in discussing it at length, it might be something you could contact one of our specialists about. I have the link there for the housing report for the reporting form, but I'm also going to put my email in the chat. Giovanni's going to put her email in the chat, so you can feel free to reach out to one of us and we can talk about this specific issue more at length.
Awesome. Well, we are hitting time, so I hate to have to end things when we're really getting in some good conversation and getting some really clear answers on stuff. But I really appreciate you, Alec and Giovanni. I think we got a lot out of today. And just, yeah, I think this was great for a community conversation. And yeah, thank you for linking those emails in the chat. If y'all have any additional questions, please feel free to email Alec or Giovanni, or email me and I can forward them over to them as well. We will be continuing to do trainings like this over the summer. Our next one is going to be on the Violence Against Women's Act, June 15th. So look out for an email from me just marketing that. It's really about serving survivors of domestic violence. So that will be from 10 to 12, June 15th, which is a Wednesday. So feel free to register when that email comes out. And I'm looking forward to another training. Thanks, y'all.
Thank you so much, Lyric, for hosting us. This has been great. Absolutely feel free to reach out to us in the future.
Have a good day, y'all.